Good morning from the North San Diego County Association of Realtors. This morning's webinar, Contracts Express, covering CAR's 2020 December forms release. We'll be reviewing new and revised forms with Fred Pfister. Also, mark your calendars for January the 20th, where Fred will cover the RPA and also the buyer's interest letter accompanying offers and the potential legal risk. To register and for an updated list of all upcoming webinars, please visit www.nsdcar.com/webinar. And now we'll start this morning's webinar with Fred. All right, Fred.
Well, thank you, Shirley. This is Fred Pfister. Some of you know me, some of you don't. And I'll give you a brief and shameless plug for myself in just a second. But we're here today to talk about the forms that we know and love. As you all know, CAR in its wisdom is always creating new forms, and this year was a banner year for forms. In fact, they created more forms this year than ever before. We won't be touching on every form that they created in 2020. But we will be touching on the forms from the December form release, and then I'm gonna backtrack a little bit and talk about the ones that came out in October of this year. But this is here's my shameless plug. As I said, I am the managing partner at White & Bright. Some of you may know White & Bright. My firm has been in North County for approximately 40 years. This is actually our 40th year, is 2021. Some of you may have known my former partner, David Bright, who is now is retired and a mediator. But I have stepped into the role for the last, 6 years or so, representing this association as its general counsel, the best association in San Diego, and I represent realtors, brokers, agents all over the county, defending lawsuits, in transactions, and really my heart is defending agents and brokers so that you stay out of trouble in lawsuits and you stay out of claims. Certainly, we're going to talk today about some risk management issues in the context of forms. That's where I always like to add value to everyone, is not only talk about the forms, but also talk about how the forms affect you in your day-to-day business and how they can affect a claim. The last thing that any of you need is a claim against you. For the classic one, of course, is non-disclosure of material facts, but nobody wants that. Nobody needs that. That takes away from your business, and it can be expensive and time-consuming. So I'm going to talk about the forms that were released this December in that context, and I hope everyone appreciates that I'm looking at it from the perspective of, okay, how would I defend this? Oh, how would I fill this out? How would I use this form to protect myself as an agent, if I was an agent or a broker? And how would I use it to, of course, protect, use it in the context of my fiduciary duties to protect my client? So that's where I look at these forms from, and that's where we're going today. So if I can move this slide here, hopefully everyone can see these slides. Here's the form. Here are the forms that were released in December. The first one is the Home Hardening Disclosure and Advisory. This one is, I'm going to call this the San Diego form, because if there's any place that in the country or in the state that you would want to use this form, it's essentially San Diego. Although there's probably a few counties up north that are in wildlands as well. But this is certainly a North County form that I know you're all going to know and love very. You're going to love it very well. The next forms is the Fair Housing and Discrimination Advisory. This is a form, again, you're going to know and love, because it attaches to every transaction, every listing agreement, every lease. So it's a new form that you're going to have on almost every single transaction. Then we're going to talk about the COP, The COP has changed. It's not a new form, obviously. You've been using this, and I'll tell you when we get to it, but I get more disputes over the COP than just about anything else. That is a form fraught with risk, and so they revised it, which is a good thing. We're going to talk about the contingency removal, notice buyer to perform, and because those have changed because of the COP. Then we're going to talk about the rent cap and just cause addendum, which is wildly confusing, and they made some changes to make it a little bit less confusing. But I'll tell you, it's still confusing. It's confusing to lawyers. It's confusing to professionals, industry, and it's certainly confusing to landlords and tenants. Then lastly, we'll talk about the square footage and lot size disclosure advisory. It's changed slightly, but we'll talk about it in the context of, its purpose, because it's a fairly new form anyway, even though it's just been recently revised. And then, of course, as I said, we'll go back over to October to look at what came out in October. So, without further ado, I'm going to stop the share of my screen here. And now you can see me if you couldn't see me before. And I'm going to pull up these forms individually. I'm going to kind of walk you through the forms and give you what I see as interesting in these forms, and again, from the context of risk management. So bear with me for 1 second here while I get this form up and running. And as I'm doing that, one thing I do want to say is I'd like this to be as helpful to you as possible. And so what I normally do these in person. 2020 and 2021 have been a little interesting for that. So those of you who have taken my class when it was in person, the one thing I start with is I like to make this interactive. I like you to ask questions. I'd like to be helpful to you. It isn't always helpful for me to sit up here and lecture. And so if you do have questions, this is a little bit harder context to do it in, for those of you who have been on Zoom meetings where people are talking over each other. It's very difficult. But please, if you can, try to put a question into the chat. I will try to look at that, although it's a little difficult to go back and forth. But certainly we'll have time at the end too for questions. And I will say this, that I may not know the answer to every single question, but I always can look it up, and I always can give you time afterwards. And so I always encourage people to give me a call afterwards. Shoot me an email after this. I'll give you my contact information, because I'm here to help the industry. I wouldn't do things like this. I wouldn't be general counsel if I wasn't here to help the industry. So I know you all have individual questions on your own transactions. So I encourage you to ask questions and make this as helpful and interactive as possible. So I will share this. Hopefully everyone can see this. This is the Home Hardening Disclosure and Advisory. This is our first form. So this form is essentially used for what it sounds like, for high fire hazard areas. And if you read the first section here, I won't highlight it here, but it's section I1, which is, this applies to high or very high risk fire severity zones. Well, what built for property built after January 1, 2010. So if you have anything that's of, more than 10 years old, essentially, or that is in a wildfire area or a high fire hazard area, you're required to use this form, or you should be using this form. That's most of North County, right? If you look at it, if pretty much anywhere north of the 78 is probably in that area, and anything west of, or east, I should say, of the 15 is probably that area. So a large portion, and even Carlsbad, San Marcos, even those areas, Rancho Santa Fe, you're going to have these high or very high fire hazard areas. And so you're going to be using this form a lot. And there's something that is that I thought was really interesting on this form, and why you may not even want to wait to find out if you're in a high or very high risk area. Now, well, let me preface it with this, that in the NHD, the natural hazard disclosure is the document that's going to label whether your property is high or very high, but you may not even want to wait for that. You'll see a line here on 1.3 that, and I don't know if you can see my cursor, but I'll just read it to you, the last sentence here, where it says, seller may choose to make the disclosures below because a buyer might consider the information material, whether or not otherwise required by law. A seller may voluntarily make the disclosures in section 2, whether or not mandated by law. So what are they saying there? They're saying that you can use this form even if you're not in a high risk area. And maybe you should, so you're not guessing of whether it's high risk. Now, of course, again, the NHD form will show you whether this is in a high risk, but it may just be a good idea to use this as a matter of course, just because you don't want to be wrong, right? I typically say it's better to over disclose than it is to under disclose, especially an issue like this, that, you know, if someone's buying a house out in Valley Center, they probably understand that there's a risk of fire. And so why not disclose it? Why wait for the NHD form to, you know, you get that in your possession in the transaction to then make the disclosure? It'd be much easier just to make this disclosure now. So once you do make the disclosure, it's in section 2. And again, this is, of course, not a form that you would fill out, but it's a form that the seller would fill out. And the seller, so this is not only a disclosure, but it's also an advisory. So it's advising here. If you see section 2 there of 2.2, I guess it would be, that's essentially an advisory. That's telling, you know, that's in bold, you know, in bold, all caps. It's telling that buyer that this is a very high risk area, and you better find out what you need to do. But so that's the advisory part, and the disclosure is the other part, right? It's the section 1 there, where you're by default you're saying it's in a high or very high fire hazard area, or of course you could check is not. You know, if it's not, you can still give this disclosure if you really want to. But then the seller has to they have to opine then about a number of things, right? They have to opine about the eaves, the roof coverings, the combustible landscaping, the windows. They, you know, and these things they may or may not know, but they have to now disclose that if they're in the high or very high risk area. Now, it seems like you know, CAR was looking to help here and saying, well, you can get a fire hardening final inspection report, and you can have that attached if you obviously check this box. And this is another inspection that you can get, you know, now that we have so many inspections, but this is yet another one you can get. And it talks about the requirements of Government Code section 51182 down here in section 4. What that section is, in case you didn't know, that's essentially the defensible space Government Code section that requires anyone in such a high risk area to have 100 feet from their property of defensible space, as long as it's on your property. You don't have to have it if you can't clear someone else's property, but it's that code section. So I understand there are companies that will come and they will do this report, and you can attach this report. You may want to use that as a marketing material, saying, look, we have a report and we comply with this, as part of your when you're listing the property. It's that would be a nice report that you had if that was a concern for people. It's becoming more and more of a concern, obviously. And it may help the buyer also get insurance. I mean, I know that's been a constant battle, and constant thing I've heard recently is that people are having a hard time getting insurance in these wildlands areas because of the home hardening requirements and the high fire risk. And so I don't know if that would help to have that report. But that would be available for you to use in the beginning here. I do see a question from Judith. She's asking why use this form in properties over 2010 when older properties may be the high fire risks. Well, actually, this is for properties that are built before 2010, and I think the reasoning is that properties built after that time have less of a concern regarding things like eaves, roof coverings. Is that these are certainly they're now building requirements that, I mean, I can't imagine you would build a new house in a wildlands area without a non-combustible roof. That was with like a wooden roof that was untreated or something like that in today's environment. So that's, so I think that was the reasoning that they put in there was the building code requirements. Now, again, you don't need to wait. You don't need to say, well, oh, my house, this house was built in 2012, and so we don't need to use this form at all. There's that was that section I read to you up here where it says you may use this even if you don't have to, just as an advisory, and I think that might be a good idea if you're in a wildlands area and you see something like and you're in a wildlands area and you want to make a disclosure along with the other disclosures, why not give them this advisory even if you don't have to. I don't see this as a deal killer for a lot of people, but it will depend on your specific transaction. Let's see, there's another question here. What if seller does not know the answer? Can you share the source of those inspections? Well, certainly if they don't know the answer, it may be important to get that inspection report. And if they're really going to take if you really have a seller taking the position that, this is obviously something they need to fill out, right? So they're the ones who would be, filling this out. I wouldn't want you to walk around the property and start filling this out. It's the same thing. I was just talking with Shirley on this Zoom call before everyone got on here that I don't want my agents or brokers filling out the TDS and the SPQ. They shouldn't be sitting there doing that. The same way with this form. You shouldn't be sitting out there filling this form out. It's certainly something you can talk to your client about, but I'd like them to fill out this form. They're the ones opining about the roof coverings. And if the question is, if they really don't want to do this or they really don't want to know, I would advise them to get that inspection report, because I think that would help them, and it would also, I would assume that the report will identify these, A through F in section 3 here, and would get them that information so that they would be able to make that disclosure. If the question is, if you're passing on information from a third party, that's always a fraught with risk. I'll talk about that in a little while about passing on information from a third party. There was a question. There's several questions in here, so I'll try to get to them. Let's see. What if your seller says they don't know if they're in a high or very high fire area, and is this in addition to the wildfire advisory? Yes, this is an addition. If they don't know they're in a high fire or very high, it's in the natural hazard disclosure report. So if you see that report, that will identify where this is. How much does the inspection cost to the seller? How much? I don't know the answer to that, Sandrine. This is fairly new in terms of, and I haven't seen that type of report yet. that specific report. I certainly see it in the I've seen it in the past in the context of just home inspection reports. They've called out things like eaves, but I haven't seen a recent or a price, I should say, on a home fire hardening final inspection report. So that's certainly something I would investigate, and I would for your office, and have someone that is available to do that if you're selling property in the really anywhere in North County. Let's see, there was something about whom would you get this inspection completed. I assume you mean the seller. If the seller got it prior to the report, that's what this looks like to me. The way I interpret this is, if you're attaching a report, this is a report that the seller would have. Now, this is also, but if there is no report, this I would interpret it that a buyer could obtain that type of report the same way they could obtain an engineering report, or they could obtain a home inspection report, or a pool inspector, or a roof inspector. It's another, it's add another report onto the heap of types of reports you can get. This is a type of report that a buyer, I believe a buyer should get, or could get. I shouldn't say should get, I said could get. Will this lead to the responsibility for retrofitting, in your opinion, like plumbing retrofitting? That's a good question. I think it probably will, because with this type of report, if it's front and center to a lot of people that people have died, people have lost homes in these wildland areas, and if you get a disclosure like this, and there's all sorts of problems with the property, and you get a report like that, people are probably going to be asking for, repairs. It's probably going to be just like a inspection report, like the traditional home inspection report. You're probably going to be getting requests for repairs. So you're probably going to see some retrofitting going on here. The issue of government code section 51182, though, is it's actually a requirement already. So if someone isn't in compliance with that, they're in violation of the law. And I don't know if you all knew that, but so let's assume you take a listing and the person isn't in compliance with that government code section. They violated the law already. And so they're supposed to have a defensible space of 100 feet. And some people do, obviously, and some people don't. And but if you don't, you're in violation of the law. So that could be another disclosure issue. There's a question here: should we order an NHD report when we first take a listing? That probably the earlier the better on it, because of this issue. That was something that triggered in my mind when I first saw that they were thinking about doing this report, this advisory. Saw it several months ago, and one of the things that popped up in my mind was, okay, we're going to need that report quicker. We're going to need that NHD report as soon as possible, especially if there is if there's an issue that may come up, or you're waffling on whether the property is in a high fire area or not. But again, you can use this even if you're not. So that's what I really would say about that. I think that's all the questions here that I see. So let me if we don't have anything else on this, I'd like to move on to the next form, which is the Fair Housing and Discrimination form. So hopefully you can see this one. So the Fair Housing and Discrimination Advisory, this is like what it says. This is an advisory, and it's really an advisory to to anyone who this is going to be bundled with the purchase agreements, with listing agreements, with buyer representation agreements, and with leases. So this is going to be like what would a similar form be? The like the wire the wire transfer advisory and things like that. This is going to be bundled when you start a new transaction, and this form is really to advise the consumer, if you will, about their rights, and about their rights not only under federal law, but also California law as to fair housing and discrimination. California is making a real push into this area to go after what they perceive as either as unlawful discrimination in housing specifically, and unfortunately, they're somewhat targeting you. And they're targeting agents and brokers and the people who own the property, sellers and landlords. But they're also targeting real estate licensees, and so that's where I really want to focus on here. So let me highlight a couple of things that I think are important in here, and then I'll talk about something that is really fraught with risk. So if you come down here, I mean, there's a citation in section 2 here to all the specific laws, so people can go look them up. And then it talks about their legal remedies, and this will scare you that that violations can result in civil fines, injunctive relief, compensation, and punitive damages, attorney's fees, and costs. So scary, right? And then the protected classes, and if you look at the protected classes, this is the California. Federal is a little bit more limited, but California is about as expansive as you can get. I mean, down to any arbitrary characteristic, which is what you make it, right? And so you can see all the protected classes here, and we don't need to get into all of those, but essentially, no, it's almost everything. And then we get down here to who has to comply, and this is what I really want to highlight here. This is section 7. Who is required to comply with fair housing laws? And you'll see here, right under sellers, landlords, and sublessors is real estate licensees, and then real estate brokerage firms. So they're really, and even property managers. I mean, they're essentially saying that you have to comply with this. I mean, this has been the law, right? This isn't new. It's just, this is now an advisory, letting people know their rights and knowing them right up front. And then they give examples of unlawful or improper housing conduct, and this is where I think it kind of deviates from previous previous issues or previous disclosures. Is that they're essentially saying, here's a setup, right? They're saying, here's if this happens to you, call us, right? That's the kind of the way I'm interpreting this. And one of these is, and let me just go through the ones that I think are the most important. And certainly A is pretty important here. Refusing to negotiate for a sale, rental, or financing, or otherwise making a housing opportunity unavailable. Failing to present offers due to a person's protected status. Now, where could that come up? Well, I see that a lot. In the context I see that is, I hear, we're in a hot market. We've been in a hot market for many years now. And during this hot market, I get calls all the time saying, someone saying that I didn't present all the offers, or someone or my seller saying I didn't present all the offers, or the jilted agent on the other side is saying we never considered their offer. Their offer was $50,000 more, and they didn't take it because it was often it's because there was a double end deal on the other side. But we've seen this too, where they say, you didn't take my offer because we're a protected class. You didn't want someone with children. You didn't want someone who was a different ethnicity than you. You didn't want whatever it is, or you just didn't like my client. And so what this is saying right here is that if you fail to present that offer, and they're protected, and they're protected status, which is, almost anything, then you could be liable under these statutes. And again, this isn't new, but it's putting it front and center here to people, that people are going to be reading this and they're going to be saying, well, why I bid, I saw this property close, I bid $50,000 more. Why didn't I get it? They didn't like me because of X. And we're gonna see claims. And so the way I look at it is, how do I protect my agents? Well, I protect my agents that when I'm presenting offers, and I have 10 offers, is we go through the offers and we have an objective criteria for them. We don't, we're not considering things like, and I'll go into this in just a second, like letters and things like that. We're doing it based upon the economics of the deal. That's the objective. That's the objective criteria. Maybe you didn't do the 50,000. You took $50,000 less because the other person was going to close in 10 days, and this person had a contingent sale on another home, or that they were putting 3% down. I mean, there could be an objective reason why you took a lower offer. And what I always advise clients to do is to document that, right? There's, document why your client took a lesser offer. If they wanted to take a lesser offer, or how they were deciding on they got 10 offers in front of them. I like to have documented an objective reason why we took a particular offer over another. And what that does is, I think it protects you from, it's nothing is 100% protective. I'll never say that, that anyone can file a lawsuit. I always tell people that, but it's a difference between filing a lawsuit and winning a lawsuit, right? You don't want them to win the lawsuit. You don't want them to be able to make the claim that it was some, that you discriminated against somebody who in presenting an offer. So I think that's a pitfall that the people should be aware of. And this form just highlights it. It highlights it. Another one on here that I can see occurring, or that I want to highlight. I'm not going to go over all of these, but is D. It's 8D. It's making any statement or advertisement that indicates a preference, limitation, or discrimination. And I would say this: we're not seeing things like, we're not seeing overt, like like it's not the 1920s. We're not seeing overt. But what we're seeing here is we're seeing things where it's indicating some type of preference, like this great for families, or you're making a statement that in your advertising that it almost steers the type of buyer you're looking for. And what the state of California is saying is, don't do that. Don't steer it. I mean, the house may be great for families, maybe a 7-bedroom house and next to an elementary school, but saying that is prohibited, and that's a steering. And it sounds counterintuitive perhaps, but that's the law. And it's not it shouldn't be necessary either. I mean, if you got a 7-bedroom house next to an elementary school, it probably you probably know that it's good for families, or that families might have a preference for it, but there's no need to include that in your advertising, because what they're saying right here is making any statement. So that's a statement that that could be any type of statement, or worse, putting an advertisement, putting it in writing that indicates a preference, limitation, or discrimination. So what they're saying is, don't do that. Now I'll go into 8E, and this is 8E3, and this one should get everyone. This should get everyone. I don't want to say excited, but probably concerned, because I know the way this works, right? I mean, I've had people personally tell me this is what works. I've had people at all the time in meetings say, well, the way I got that house was my client sent a letter. They sent a dear seller letter. They included a copy of their family. They talked about their military service. They talked about, that all the great things. They talked about how they overcame this and that in their life. And by God, that's how we got the property. We were competing with 15 other offers, and they just loved the family that I sent that letter for. Well, guess what California is saying is specifically prohibited. And as Shirley was saying in the beginning, I'm actually going to, my next presentation, I'm going to go in much more detail on this. For the next presentation, we talk about the RPA, because this really comes up more during the RPA process. But California is saying that asking for or offering buyer personal information or support letters, especially with photos, as those letters may inadvertently reveal or be perceived as revealing protected status information, those are prohibited. So they're saying, and I don't know how you send a dear seller letter without including personal information that might reveal a protected class. I mean, the fact that they're married could be, that, you have maybe it's a same-sex marriage. Maybe they have children. Maybe they're of a certain ethnic group, and all of that, I mean, is likely in your personal letter, right? That's, I mean, it's hard to write a letter without a personal letter that is, anything but generic, without including some type of protected status information. And California is saying now that is unlawful, which is, I think, is probably, if anything on this is a change for people, that's probably it. That's probably the biggest one. And I'll tell you, at CAR, that was, with the attorney panel, that was one of the biggest topics of discussion, because it came up, and because this is the way people do business, right? People, like I said, I've heard of dozens of transactions where that made all the difference, right? And that's how we got the property. But now they're saying that you can't do that, because it would inadvertently disclose personal information of a potential protected class. So the question, of course, then is, okay, what if I get one of those? And the statement from CAR was to return it and say, we're not considering it. But then, of course, the response of other attorneys, well, is that in my, what about my fiduciary duties? I'm supposed to give my clients all the information I receive. And so what the advice was to talk to the client at the listing and saying, this is on the seller side, at least, that we're not going to ask for those. We're not going to accept one. If we get one, here's what we're going to do with it, so that you're telling them up front that you're not going to be passing those on, if you get them. Now, will people still do it? Of course they will. I wouldn't have a job if people followed these forms and the law to the T. And thank God, because I got two kids that need to go to college. So that's a joke, but I encourage you to follow the law on this and just have that conversation up front when you're having the listing, that you're not going to be accepting those, and then don't provide those. And so I guess we have a couple questions here. So let me see what they are. How about suited for multi-generational families? That, I don't think that's probably a more of a gray area, but it could be steering a little bit that this is, is that a protected class? Yes. I think that's probably a better statement, though, than suitable for for children or for families. But that I think we'd have to look at that specifically. What does this say here? What about disclosing information on solicitation postcard? I am working with a family looking for a new home in your area, interested in selling. Is that off limits now too? I don't think that's off limits, because you're not necessarily, I mean, if it's that generic, and that's the point, is that if it's that generic, I think you're probably safer than if you said, I'm looking, I'm looking with a veteran, a family of 2 veterans with 3 children in school age that, are of this ethnicity, or there's a picture of them. It's, no one says, we're this ethnicity. They just include a picture, which, somewhat does that. And so I don't think that a very generic statement of we're looking with we're looking for a home with a family is as problematic as including any real information that is would fall into one of these categories. There's a few here, a few more questions. I think that the sellers can look up the names of the potential buyers on Facebook or any other social media platforms, even without the letter. I completely agree. And that actually came up as well during that CAR discussion. Well, what are buyers or what are sellers now doing? Sellers are, the minute they get an offer, they're going to Facebook, they're going to Instagram, they're going to whatever it is, and they're not just looking up the seller, the buyer, they're looking up all the information they can get. Where does that person work? Where does, there's a lot of information that's out there, and I don't see why that's our job to police it. And I wouldn't want you necessarily to police something like that. What I'd like to see is I'd like to see you not, complying with the requirements of not steering and not discussing that type of information with the, certainly not advising them on something like that, to consider that information. That shouldn't be a discussion, and it should be, if that is a discussion, that's something I would shut down to comply with the law. There's a lot of questions on here, so I'll see what I can get to. Can you present the offer to seller and tell buyer's agent that we will not be accepting the cover letter and we will not be showing it? Yes, that's what I would do. That's why I'd have the discussion ahead of time with the seller, saying that this is the policy we're going to follow, and if we get that, that's going to be our response to anyone. Because no matter what you do, you're going to get that letter, right? There's people who didn't attend this meeting. There's people who aren't going to attend other meetings where they talk about this, and there's going to be people who attend this meeting and still do it anyway, because frankly, let's be honest, sometimes this works, right? I wouldn't have the anecdotal stories to tell you if it didn't work sometimes, and so people are still going to do this, and they're going to violate the law. And so if you want to comply with the law, if you want to have best practices, what you're going to do is you're going to shut that down. And that's the way you would do it. Someone said, what about the words master bedroom? Now we're kind of getting into the, what may be more of a political discussion of whether you can use those types of words. I don't understand that. I don't believe that one's been banned yet. I think it's been disfavored though. And so it's, do you want to get on the train of using the words that, that will be more inclusive or less inclusive? So I don't want to give necessarily an opinion there, because I don't think that's a legal opinion necessarily. But you can, that is what I've heard. That's a word that's being disfavored in the word master bedroom. Let's see here. Are then dear seller letters off limits, or can you give any detail at all in a letter? If so, what kind of detail can be included? And that's really the crux of it, is that I don't think they're necessarily. I don't interpret this as they're off limits entirely, but if they have any revealing information about a protected class, then that's prohibited. And so if you look at the protected classes, I'll go back up to it. how do you give any personal information in a dear letter, a dear seller letter without giving one of these protected classes? What are you going to talk about? Are they a military veteran? Are they going to talk about how you overcame cancer? That's a medical condition. Are you going to talk about whether you're same sex or not same sex? That's a protected class. Are you going to talk? Are you going to show a picture that's going to show race, color, perhaps something like that? Are you going to tell them about how they came from another country and overcame these obstacles? That's going to be national origin. I mean, you name it, you're going to get to. You're probably going to get to some type of, if you have any real detail about the family or the person who's buying it, I shouldn't even say family, right? The person who's buying it, then you're going to hit one of these protected classes. And so it really limits what the dear seller letter even looks like at this stage. So you may just want to stay away from them altogether. So you don't have the expectation that, because once you ask the seller or once you ask the buyer to create one of those letters, I mean, it's going to be so hard for them to create one that has any meaning other than something that looks like a generic postcard that you get in the mail. Then you may want to just steer away from them altogether. So where does it say on the form that you can't have these type of letters? Well, if you read it, it says the examples of unlawful or improper housing conduct is the following: having, promoting, or encouraging housing practices that may not be motivated by discriminatory intent, but have a discriminatory effect, which legally sufficient justification such as. So what they're saying here, they're not saying do not do a letter. What they're saying is this is an example of something that has a discriminatory effect. And that's strange to people, right? Because once they think, well, I didn't write this. My intent wasn't to discriminate. I was just writing, I just asked my buyer to write a letter. I didn't want to discriminate, but it's not the intent anymore. It's the effect. Does that show a seller some protected class or something that would have a effect if they pick that person? And it's scary because you don't even have to have the intent anymore. As long as the conduct has the effect of having possibly being discriminatory, it's unlawful. So that's I knew that would be a hot topic. That's why I wanted to highlight this. I do want to move on to the next form though, but just know that that will be the topic of actually my next discussion. Shirley can tell you when it is, but it's on the North County website. So if you go to NSDCAR, you can see that I'm doing a presentation on the RPA and dear seller letters because it's fraught with risk now. There's not just A through F though on these examples. They continue on. They go through all the way through P. And the other one I want to highlight here is is M, which is probably it sounds very generic, and I would put it to you that it is pretty generic, which is taking an adverse action based on protected characteristics. And what does that mean? I mean, what is an adverse action based on protected characteristics? I think that really that can lump everything in, right? An adverse action is what? Not completing a sale, or not picking an offer, not accepting them as the renter. It's kind of like a catch-all. And so I just wanted to highlight that one because, if you want to say, they can fit almost anything into this as long as there's a protected characteristic out there. Let's see. So I see a couple people here. One person saying, Elizabeth is saying, I've seen no buyer letters will be accepted in the confidential remarks at MS and the MLS lately. that's a reaction to this form and to the new policy. So Dawn is saying, my broker said that the buyer letters can cause the seller to discriminate, so we should stay away from them completely. And that's again what, if that's exactly what CAR is saying, well, the state of California and then CAR is saying here. That's what I'm that's exactly what I'm saying as well, that seems to be their position here. And that would be the best practice for you if you were to stay away from these letters altogether. But like I said, I don't think that's reality. I don't think that people are going to stay away from these altogether. And so it's having a practice and procedure on your own part of how you're going to deal with them as a seller's agent, and what you're going to do. The last one I wanted to highlight is they talk about the examples of positive practices. And I particularly like E on this, and to highlight here is kind of what I was talking about before, which is having a selection process that relies on objective information. So when you're counseling your client, your seller in this case, or maybe you're the you're the agent for a landlord, having objective, you're evaluating based on objective criteria, not the, oh, do I like the name of this person, or let's Google them and see what they do, or let's check them out on Facebook and see what they're posting, because that gets you into that protected characteristic and discriminatory intent area, where if you have objective criteria like their credit report or their or what the offer looks like on, the financials of the offer are that's a much better review. So that's really what they're suggesting here. And just to kind of close this form, the buyer and seller are to sign this form. There's a question of who and when to prepare this form. So this form is an advisory, right? This isn't a form that anyone really needs to fill out, because there really isn't anything to fill out on it. It's just an advisory. It's to be signed by the buyer and seller, or the tenant and landlord, depending on what the criteria, what type of transaction it is. But it's something that just needs to be signed by them, that they got it. And so some people will get this form and they will sign it and they will never look at it again. Some people will study this and say, my gosh, they did this, they did this in this transaction, and that's why I didn't get the house, or I got steered towards, this neighborhood, and that was unlawful. So what this is, you don't really know who your client is, of whether they'll read this or whether they'll throw this in the garbage. But this is a new advisory for virtually every transaction that's going to have to be signed and be part of the file. Okay, so let's move on to the COP, because I know this is, as I was saying in my opening, this is something that I've seen a lot of problems with in the past couple of years. I'd say there's almost more disputes over the, obviously the most disputes are always non-disclosure material facts, but in terms of transaction disputes, like while you're in the midst of the transaction, other than people trying to cancel, I see a lot of problems over the COP, and I think the function of it, of course, the reason why there were so many problems over it was the fact that housing is extremely expensive in San Diego, and most people, when they're buying a new house, they need to sell their old one first, right? And some people like to do it all at the same time, or they like to, they don't want to be living in a hotel for months, and so they're using the COP form, and so what CAR did was they really revised this. And if you look at this, if you look at the screen share I have here in front of me, you'll see all the red. And I'll just kind of scroll through this so you can see how they really, they really almost rewrote this form. Now, a lot of the information isn't new, but it's been reorganized, I think, in an easier to understand format. because like I sound like a broken record, but I had so many disputes over this because people don't understand what it necessarily means or what the procedure is. So I would encourage you to read this form and get familiar with it, because a lot of transactions include this. There's a couple of things I do want to highlight other than just the reformatting of this. One is that in terms of this, they've really made 7B the that whole backup offer issue. The old context of this is that you enter into a contract with someone, they have to sell their property to complete the transaction, but you want to have the ability to take a backup offer and have them release their contingencies if you have that backup offer. And so if you do that, this is where you're really going to have to study, which is the 7A, B, and C section, whether you're the buyer or the seller on this transaction. Do you want, the default is the immediate right to notify seller that anytime after acceptance, you can push them to waive their contingencies, right? And remove the contingency of selling the property, remove the loan contingency, and provide verification of funds. And they've actually changed if you look here, for those who are kind of nerds on this, they've actually changed it from 3 days to 2 days now for this by default. But the default is the immediate right to notify buyers, so that if you have that you have that backup offer, and you can push them to waive these contingencies. But if you're on the buy side, you might want to delay that, and so you may want to look at C2 or 3 here, so that you can you have some time frame to rather than remove those contingencies, because there's a lot of risk obviously in removing those contingencies if you haven't sold the previous property. They've also modified this form to give you additional options for cancellation based upon the buyer's property sale if it's not moving along. So in the past, it was mostly if they didn't close the escrow, or they gave some type of notice that the property had fallen out, the buyer's property had fallen out of escrow. Now they have additional rights to cancel based upon whether they put it on the MLS, and whether there's been a removal of contingencies. And so they're basically giving more outs to the seller. And they also give additional outs to the buyer, right? So the buyer has additional contingencies to get out of the transaction as well. If they, for instance, if this section here is new, this 9, it would be 9I, if they're unable to enter a contract on the buyer's property. So what I would encourage you here to do is, if you're going to be entering into a transaction that includes a COP, is that you need to really read this new form. This form has been radically changed. It is not, while there are some things that are the same, they're all in different locations, and it reads a lot different. So I would strongly encourage you to read this and go over this in detail with any buyer or seller, so that they know, okay, what are our rights to cancel, and what happens, what do we do if that happens? Because I'd say a lot of these transactions, especially in a hot market, sellers want to sell, and they think they have the upper hand, and so they will. And if they get another offer in, I mean, I can't tell you how many times in the last 6 months I've got the same call. I'm buying this house, and seller now says they're not selling anymore because they actually told me they had a higher offer, right? And they want to get out of the transaction, but I want to keep them in. And if there is a COP involved, they have a lot more rights than if there wasn't a COP involved. If I'm representing a buyer who's using this form, I want to give them I want to go over all the seller's right to cancel. I want to walk them through the scenarios, because what they may end up saying is, gosh, maybe we shouldn't use this form at all. Maybe we should just sell our house first, live in a hotel for a month, and then buy a house, because it's quite a thing to get involved in a transaction, and then halfway through it, you realize that you're not getting the house anymore because they've send you a notice of buyer to perform, and you can't waive that contingency. You can't waive the financing contingency, for instance. Maybe it's impossible for them. So I would really think twice about using this form if you don't need to. That's kind of anecdotal, but that's from my experience of seeing a lot of disputes over this form. But hopefully this new form will make it somewhat better. You also see here, I want to highlight this, the contract obligations other than the deposit. This is similar to what it was before, but I think this is I like the header on here because it really highlights this, that, okay, we can move these dates. I don't think it was as clear on the last form that the time periods in the agreement can shift based upon the occurrence of these items. So you can either have the time periods in the agreement for the inspection contingencies or close of escrow, or you can have them shift based upon these items here, which is 10AI, 10A 1, 2, or 3. But I like the format of this. So I like that they've kind of highlighted it now as this is the time requirements. Please, again, study this form. It's important if you're going to be doing a COP. You'll notice that something else is gone from here on this new form, that they remove the confirmation of receipt. There used to be a confirmation of receipt on the COP form where they could accept, essentially. They could accept the contingency removal. Now they have moved that to the contingency removal form, so the CR form. So maybe that wasn't clear. Let me say that again. That on the bottom of the old COP form, there was an area to accept, and now that has moved. So where has it moved? Well, it's moved to the contingency removal form. And so you'll see now on this form, that contingency removal, the CR form, which is new again for December 2020, they have added this section specifically to deal with the COP. So you'll see the new 7A and B. This is where you can remove, if you're going to give someone a notice to perform and they want to remove that specific contingency, this is where they can do it. And they actually split the two. This is new as well. They split entering into contract for sale of the buyer property from close of escrow for buyer's property. So those are two separate things now. And that actually carried over into the last agreement we just saw, the COP. They really split those two issues, entering into contract and closing escrow, because they're really two separate things, and they're two separate types of contingencies, right? One gives you some assurance, they're in a contract. The other one gives you all the confidence in the world, right? You've closed escrow. So two separate things. Just know that has changed slightly. And similarly, the notice to buyer to perform has reciprocal changes. You'll see here again what contingencies you're asking them to remove this contingency of the contract and the close of escrow. Again, they've split those two, or this contractual action of giving them evidence of removal of contingencies in buyer's property, deliver a representative capacity signature, and evidence of listing of buyer's property. So they're splitting up these different contingencies. And I think that's good because these are different things and they do give you more confidence. I always like to see, okay, you removed a contingency, removed. That gives me more confidence that the transaction's actually going to close than if I'm waiting for, if I'm just waiting for this last thing at the end. And guess what? I'm waiting. And then I find out that they never even removed contingencies 3 weeks ago when I thought they were going to, right? And they could have told me 3 weeks ago. I don't know how many times I've seen that. As another anecdotal story here is I see people where they say, well, we're supposed to close, but now I just heard, we're supposed to close tomorrow, and I just heard that the other transaction isn't going well, and they never even removed contingencies 3 weeks ago when they were supposed to, and that process is being delayed, and they never told me. Well, right here's a way to kind of force that on them, right? You could as the seller, you could force that on them. Give me evidence of that, right? So this helps, I think, clarify the COP and doing so with this notice to buyer to perform. Okay, next form, we have 2 more forms in December. And this one is the one that everyone loves. And I'm not going to go into the explicit detail of what rent cap and just cause is. When I opened with, these are utterly confusing to a lot of people of how rent cap and just cause applies. And I'll tell you, it's not only confusing to you, it's certainly confusing to landlords, and it's even confusing to a lot of attorneys that they created a bill where they tried to fit the entire state of California into one bill and all the different housing options, and so what did they do? They created rent caps and how you can evict people, and then they created all these exceptions, right? Well, if the property's if it's not 15 years old, then if it's less than 15 years old, then it doesn't apply. And if it's if you're going to take the property, if you're the landlord and you're going to be renting it to grandma now, that applies. That's you can do that. That's not that's prohibited, or it's not prohibited from the just cause eviction. So again, I'm not going to get into the detail of this because that could be an entire presentation itself as to, does rent cap apply and does just cause apply to my property? I would strongly encourage you, if you're dealing with that type of issue, to consult your attorney. Shameless plug, White and Bright does that type of work, but other attorneys do as well. And I know people are always looking for an exemption on this. Do I have to do it? And you hope that no, but if you do have to do it, you'll have to provide these addendums. And so one of the things that you'll see on here, one of the changes that they've made is they've put this front and center. I think I'd say this is the biggest change. You can see there's red on this entire document, but what they've really changed is they've changed this notice of exemption right up front, where and the intent, I understand, was to make it prominent that people could just check that and not have to deal with the rest of it, and not have to. And so, especially for landlords that that the kind of the self-represented landlords, not the big commercial people, but the individual, so that they can check this box if they are indeed exempt, and then that would be then they'd be essentially done with the rest of the with giving them this requirement. And then the rest of this document is essentially an advisory as to what here are the at-fault reasons, here are the no-fault reasons, here are the just cause notices. Again, I'm not going to go over this in detail today, but just know that this form it's been clarified a little bit and made it easier for what I would call the mom and pops to say that they're exempt if they are indeed exempt. But I would not necessarily be opining on that for clients. That's something that would be akin to legal advice, and your best practice on that is to refer them to counsel. As unfortunate and as expensive as that may be, this is a law with as many loopholes as there are requirements. I'll just put it that way. But know that form has changed. Last form in December that has changed: the square footage and lot size disclosure and advisory. For those of you that know the history of this form, this really came out of the Hariki case, where there was that famous case that came out a couple of years ago in Malibu, and that had to do with fiduciary duties of agents and brokers. But it was all over, what brought it up? Well, it was a discrepancy in the square footage of the property. As many of you know who do these types of, who sell homes that aren't cookie cutter, it can be very difficult to get the, correct square footage of homes. It can, you also have a lot of discrepancies with add-ons. I can't tell you how many times I've heard people say, well, yeah, it's 1,500 square feet, but there's this deck on the back, or there's this other room. We're not sure about permits. The property records, the tax assessor doesn't show it, but here we have this plan that shows it. And so what this form was intended to do was to disclose that type of information, because it was very difficult in the past, or it was I shouldn't say it was difficult, it was cumbersome to say, well, property records say 1,500, this other report says 2,000, but I've measured it myself, or I have this other appraisal that says 2,200. And so you'd have this kind of conflicting information, and there was always this question of, okay, what do I disclose? How do I disclose this? Do I even disclose it? Because people, of course, the sellers wanted to use the higher amount, right? They wanted to say 22, because when you're doing a per square foot, most houses are priced on a per square foot basis. And so that was always something, they're always trying to get a higher number. And so they came up with this form, and it was actually last updated in June of 2020, if I'm not mistaken, but they updated it again. And one of the things that they did here, and this is just in red, so some of you have already been using this form or already know about this form, is they inserted something that was really useful, I think, here. It's only just one sentence, but it says, even if no numbers are inserted, the rest of this form may be used as an advisory, which I really liked, because you had this, the feedback that I heard from people was that they got this form, and then they felt that they had to go out and and find the public record, and they had to find the appraisals, and they had to find all these things. And it was almost like they thought that they had to do this work. They had to go out and try to find the architectural drawings and the floor plans or the survey. And because there was there's a blank on a form, I got to fill it. And so I think it's helpful to say that it says on, to have it to say on here that, even if we don't put anything in here, we're still providing this form. I think that helps a little bit, so that people don't feel like they have to include this information. And so they also, included this these additional disclaimers here regarding, other measurements, and acknowledges that they've read this. And so, and also for the buyer to say that this, if this is material to them to investigate, for what that's worth. That's always helpful when we're defending these cases, to say, well, if this was material to you, here it was in big bold print, that if it, did you get this measurement? Now, do a lot of people do this? Of course not, but it is, it's an advisory out there, and if that is important to them, they have the opportunity to get that. there's one issue here that I wanted to raise, and it doesn't necessarily go with this. Well, I guess it does go to this to some extent, but it's attributing source of information. For those of you that have taken my other classes or have seen me before, I do several classes on either what we call red flags or essentially non-disclosure material facts, how to avoid litigation. And one of the things that I focus on religiously in those type of classes, and I just want to raise it here because it kind of dovetails with square footage, is the source of information. One of the things that we often see in transactions is the broker or the agent, particularly the agent, will get information from the seller or from some other third party, and they don't just and they pass it on as the truth. And that can be extremely problematic because it may not be the truth, right? But people say, well, wait, why can't I rely on those people? Well, you can, but what you're supposed to do, there's actually a case on this from the 90s, that if you're making representations of facts that might be material to the client's decision to buy the property, which, let's be honest, it's almost anything, right? They'll always say it's something. You either have to say that you're merely passing on the information and about it, and you're not verifying it for accuracy, or you have to verify it. And I don't necessarily think you really want to verify it, right? You get some drawing of some floor plan. You didn't actually go out and measure it. You didn't verify it. But what you can do there is say, we've received a floor plan. I'm not verifying the, buyer, we just received this floor plan disclosure. I'm not verifying this. If you want to, talk to the company, it's been received from X company. If you want to talk to them and you want to verify it, go ahead and do it. Some version of that. It's actually called the Salahutin case. But like I said, I go over that in much more detail in my non-disclosure and litigation avoidance classes. But just know that if you're passing on information from a fact, you either have to verify it or you have to attribute it, and make sure that they know that you're not verifying its accuracy. Where we see this a lot too is seller will give some information and they won't be attributing it. So just know that's an important thing out there. Look for it, and again, take my other classes if you want to go into any more detail on that, on litigation avoidance. This is also a good spot to do another plug here for. I was attending a Glide presentation yesterday, and I know some of you have heard that Glide is coming out in much, and I know a lot of you have been using it. I just heard the statistics on how many people are using Glide. And something that was interesting to me with Glide, because they're expanding the disclosure forms for Glide, is that they're actually going to be highlighting problematic words and phrases that when people put those types of words and phrases inside of disclosures. And what those are things that talk about the severity or quality. I don't know how many times I have done a presentation where I've said, don't use disclosures as marketing materials. Do not go in there and minimize issues. Just tell the facts and nothing but the facts, right? Don't say, well, this is a small or it's a minor issue, or it's a where you're saying whether it's the severity of the issue or the quality, right? I would even go a step further and say and attribute it to a source. But the reason why they're doing that is this litigation avoidance, right? Is that's where we see claims. We see claims when people try to minimize problems, either in the AVID or the TDS or the EQ, where they're saying, they're trying to minimize the extent because they think that if they tell I don't want to necessarily say tell the truth, but if they disclose all the facts, then that person won't want to buy the property. So Glide is actually going to be working on that with I don't want to call it AI, but certainly problematic words and phrases. So that was kind of interesting to me. I thought I would highlight that here, even though it's not necessarily a new form, but it sounds like it's a new, it's an expanding area that will help you avoid litigation, avoid talking to me offline, because you're not going to be accused of things, because people are going to be, they'll be hopefully not getting in trouble at all on these issues. Let's see. I have a couple questions in here. Did we miss changes to the NBP? No, we didn't miss changes to that. What the changes were to conform the NBP to the new COP. a lot of acronyms there, but the changes were pretty minor, but they were to conform the COP. Oftentimes, when we do these forms, or when they make changes to forms, it has a cascading effect on other forms. And so one of the cascading effects of changing the COP the way they did was they had to change the contingency removal and the notice of buyer to perform. So just know that the changes to the notice to buyer to perform were just to expand on the COP. And then there is a question back to the HHDA. Technically, are sellers liable after the sale if requirements were not met, i.e. 100-foot dispensable space, and does the form protect them from that liability? Well, that's Joy Lynn. Thank you for that question. That's somewhat of a loaded question, because if they're not met, let me think about that question for a second. So if you're providing a report that says it is met and it wasn't met, then maybe you have an issue. I don't necessarily see that, though, if you're just disclosing, just giving them that advisory, where that would come into play, how you would be liable for that. Now, the huge caveat I have to that is the fact that people can make up anything after the fact, right? They can come up with any novel theory of why your seller is liable for something like that. They could say, well, you disclosed this and it was really that. So I would really have to look at the specifics of that transaction to see whether because I'd hate to say I would never say there's a blanket protection from liability in all cases and circumstances, because oftentimes it comes down to not only the truthfulness of the disclosure, but the what I would call the interpretation of that disclosure. I can't tell you how many times I've seen where there was a disclosure on a document that we disclosed that there was fill on the property, right? But what kind of fill? You didn't tell us that there was this type of fill, and we suffered damages because of it. And then the seller is saying, well, I disclosed fill, right? I disclosed that there was fill on the property. I said it was uncompacted even, right? But you didn't disclose that there was XYZ in it. And so sometimes it's not just the disclosure, it's the interpretation of that disclosure. So I hate to give a blanket statement that something protect you from liability. There was a statement about, I received a notice last week that Glide was being dropped by the CRMLS due to illegal violations by Glide. So that's not the information I received. So I was on, as I was saying, I was on a call yesterday with, a Zoom presentation with the Glide CEO and actually the general counsel from CRMLS. And actually the CRMLS is actually going to be integrating, and CRMLS, if anything, was plugging Glide. The legal dispute seems to be between Zip Forms and Lone Wolf and Glide, and I won't comment on that at all, because frankly I'm not a part of that, and that's not my place to comment on that. But I understand that a lawsuit has been filed by the maker of Zip Forms against Glide. So how that plays out, we will see. But I know that at least from the CEO of Glide yesterday, North County is, and really a lot of the state is adopting Glide like crazy. I think because of the coronavirus pandemic and the ease of use of having an online form versus, the more traditional paper or, even e-signed forms. So, I don't want to get into that because I don't know the details of that lawsuit or anything of that dispute, but just know that I thought it was really interesting that we're getting, we're actually having, I hate to call it AI, but we're having helpful hints to help clients through their disclosures, that things like steering them away from problematic words and phrases that's where the future is going here, and that can really help you as well on this. As we get yet more forms, right? We have. I have an entire book like this of, if people can see me, of forms, and they just get more every year, and which is a great segue into the last thing I wanted to talk to you about. If I can stop the share for a second. And I'm not going to go into incredible detail on this because, in the interest of time, and also hopefully that most of these forms will be going away. But let me see if I can share my screen yet again here. Hopefully you can see this. So in addition to the, when I think I opened with saying that this has been a banner year for forms, that's been more forms created this year than any other year. Well, that's true, and that's true for one reason. Coronavirus. So the coronavirus has created, if any of you, I know the PED form is near and dear to everyone's heart. Everyone loves that PED form and all its iterations. Well, they also created a whole number of forms, other forms to deal with the coronavirus. I mean, unprecedented. Normally, they just create a couple forms a year, and they modify a couple forms. But in September/October of this year, they created 15 separate forms that were all brand new, which was again pretty much unprecedented. But and I break these forms down into two types. And let's see if I can share my screen here again. Hopefully you can see this. Hopefully you can see that. Basically what it is I see they had two types of forms, and these really had to do with the financial coronavirus forms and what I would call the notices. So the financial coronavirus forms were things about rent forgiveness and repayment and a declaration that you're not able to pay, and let's calculate our rent. And the notices were essentially advisories saying these are your rights under coronavirus. And then a massive change to, well, I shouldn't say massive, I should say a change across the board of how you give people notices to cure, notices to quit, notices to pay. All those notices that you typically used for the eviction process, notices of termination, all those documents that you gave, they had to modify all those. Remember when I said the cascading effect of you make a small change in eviction law, and all of a sudden all the forms that you used have to have a caveat. Well, these don't apply during this time frame because of this emergency government order, or these, you don't have to pay rent for this period of time because of this emergency order. So they made this massive change to the law of eviction, and it had a cascading effect. And so CAR, they did a bang up job here, but they went through all these forms and basically had to recreate all these forms to comply with these temporary orders. So some of these forms that, I'm going to go over fairly quickly here, but a lot of these forms, have pretty much already expired. These forms have, they ran until, September 1. And even though they were coming out in September, their usefulness is going to be less and less important. And in a lot of these forms, you won't even see a year from now. Maybe you'll see a whole slew of new forms with a new coronavirus or some other thing, but a lot of these forms will be going away. So that's why I wanted to kind of save this to the end to say, well, you can read these forms, and if you do property management, you probably are all over these forms. But if you don't, hopefully you're not using these as much. But I'll just go over them fairly quickly here if I can. Let me see how I can get these up here. Bear with me for 1 second here. So let me see here if we can get this one up first. Okay, so hopefully you can all see that. This is the Centers for Disease Control COVID-19 Tenant Declaration. And like I said, these are for these are forms that were essentially mandated by they weren't mandated, but they arose out of the orders from the state of California and even federal forms. And so if you look at this, this is for a tenant that can't pay, right? This is a declaration that a tenant would, to landlord, I can't pay, and here's why, right? Because I make less than $99,000 a year, and and I've done all these other things. I've used my best efforts to make these payments, and is this something that they would provide so that someone couldn't evict until after January 1. So remember I said that some of these forms are somewhat moot. Well, here you go. This is one that was supposed to end on January or December 31st. So the fact that you might not use some of these, but again, if you're looking to evict someone, I strongly encourage you, if you're on the property management side, to consult with your attorney, because there's just overlapping laws. Being able to evict someone before February of 2021, that was something that came down. I know that people have tried to get in to get summons to get that eviction, and they haven't been able to. So before you do any type of eviction, I strongly encourage you to use counsel. But here's a type of a form that was supposed to be temporary in nature, and here we are. Even though it was in October, it's almost expired already, right? Because it was supposed to be for prior to December 31st. But again, this is one of these, what I would call the financial forms. Here's another one. This is the rent forgiveness, termination of tenancy. This is essentially a termination agreement. I'll tell you, unfortunately, I've done many of these on the commercial side. This is obviously a residential one, but I can't tell you how many commercial termination agreements I've had. It's an absolute travesty in our state that from your painting pottery places to your restaurants to your breweries to gyms, it's just been a cascading effect. I get a call just about every week from a commercial tenant or even a landlord saying, I got a problem, they're not paying rent, or I can't pay rent. And so we do, again, a shameless plug, my firm does those types in the commercial process because those are there's a lot more issues than in the residential side necessarily, but this is the residential form. So if you are doing a termination of tenancy, this is the form that you would be using for coronavirus. there is, but you may have an unpaid rent repayment agreement. Some of you saw this. This form is to be used for that repayment plan. I haven't seen a lot of people doing the repayment plan because, frankly, if you can't pay now, are you really going to be able to pay in 6 months? For a tenant on a residential lease. But this form is out there. What I've seen more is rent forgiveness rather than repayment plans. But if you're doing a repayment plan, here's your form. And the next one is the unpaid rent calculation. So this form is a form to be used to show how much they owe, because frankly, you could have done this in an email. You could have sent this. You could have said, "Hey, here's a breakdown of what you owe and why you owe it." But CAR put out a form for it, probably to standardize it and to. I'm not sure exactly why they felt the need to do this form, but it does, I think, help you keep you organized, especially for the mom and pops out there who may not be as organized. This would help you to clearly state to your tenant what they owe and why they owe it. And so you can see it goes from March to January 2021. There was when they created these forms, I guess there was a thought that this we'd be rounding the corner on coronavirus in about this time, but of course it doesn't look like that's happening. Knock on wood. Hopefully that will happen soon. But here's your form for creating unpaid rent, or at least notifying them of unpaid rent. The next, what I would call financial form, is this notice, which is something you have to give them before you're going to evict someone. You're supposed to give them this type of notice. Or I'm sorry, this is the declaration. Sorry, this is a different form. This is the declaration that they need to. The next one's the notice. So this is the declaration that they satisfy the requirements of the state, of local and state law, that a tenant provides to give notice of hardship. So if they have a hardship, this is what they're supposed to provide ahead of time. A lot of people aren't necessarily doing this, but they are supposed to do this in order to qualify under certain law for coronavirus relief. But again, I don't want to steer you to say this is all. I would strongly encourage you, before you do any eviction, to consult with your attorney, because there are so many requirements, and there's local and there's state requirements, and they're overlapping, and they're constantly changing, as you can tell by them putting out 15 forms, and some of these forms aren't even useful at this point. The last, so that was, I believe, 5 forms there. The last number of forms are notices. So these are all the change in notices to tenants based upon the coronavirus relief. So I'm just I'll go through these fairly quickly. Just give me a second to bring them up here, so that we have them all. Just bear with me for 1 second. Okay, I think I have them all here. Let me share my screen real quick. So the form you should see is the Notice of Tenant of COVID-19 Tenant Relief Act of 2020. This is a new form that you must give before you evict someone. So it kind of dovetails with that tenant declaration we just saw. So that if this is a notice that, if they have a coronavirus issue, that they could have given you the declaration. So they kind of work together, as you can tell. And And what this one allows them to do, and again, it's, this is expiring, right? So this is one of these expiring before forms, January 31st, 2020, 2021. That's, that's in a couple of weeks, 3 weeks. It allows them to pay less. So it allows them to pay, you cannot be evicted if you pay 25% of your rental payments missed during that time frame on or before January 31st. So if this is probably important to all of you, that if you have landlords that you're representing that haven't been receiving payments and they haven't been able to evict, they're probably very upset. And they're probably calling you and they're saying, well, when can I go after them? Well, here it is, this January 31st, except if they pay 25% of what they owe, which isn't a whole lot, but that's where you get that rent calculator. So that, that you get that form with all the rent calculations of what they owe. And then you figure out whether they paid 25% or not. And if they did, then you can't evict them, but then you use that repayment plan. These all kind of work together. But this is the notice that the tenant must receive before you evict them, that essentially gives them their rights of what they can do before they can be evicted. Okay, next one, the notice of termination of tenancy, COVID Tenant Relief Act, yet another notice. This gives them, this is supposed to be used before the end of January. You can see this termination of residential tenancies prior to February 1. So this was intended to only be if you terminated their lease for something other than the non-payment of rent due to coronavirus. And so that this form is, again, a limited duration. So I'm not going to spend a whole lot of time on it. The next document is the Notice to Cure or Perform Tenant Covenant or Quit, COVID Tenant Relief Act. These have wonderful names. This is another form with expiration. You'll see that this is for non-payment of monetary, at least it's helpful at the top here, that this is for non-rent monetary obligations incurred between March 1, 2020 and January 31st, 2021. So it's essentially yet another notice that will be expiring very soon. But if you're evicting someone for a monetary obligation, use this form. Next form, the Notice to Cure COVID Protection Period. Or I'm sorry, this is the wrong form. Which form is this one? There's so many overlapping ones here. Just want to make sure I have the right one in front of me here. Okay, Notice to Cure or Perform Covenant or Quit. This one is, you can see here, at least they give you instructions at the top of when to use this form. And, they want you, if you're using this between this period of time, use it, they want you to use a different form. So this would be the form that you're using after that time frame. So again, this is essentially the Notice to Cure or Perform Covenant or Quit. So this is one of these updates of these traditional forms that you would have used to evict someone. This is really giving them it's informing them of what your obligations are under the code in the context of the coronavirus pandemic. Whew, that was a lot to say. The next one is the Notice to Cure COVID Protection Period Monetary Covenant or Quit. If you look at this one, this is pretty much already expired. This one was between March 1 and August 31st. And you're thinking, well, why do they have, Fred, why do they have all these time frames? Well, it's because they kept changing the law, right? So they would change the law for what can you do during this time and what can you do after this period. So it's like this minefield of you're trying to figure out which form is the right one. But luckily, they have this handy statement at the top of each one of these forms of when you can use it. So before you do anything, make sure you get the right form and then follow what it says here. Again, if you see here's the statement. If property owner is uncertain whether the property or tenancy is exempt from TPA or subject to a local ordinance governing rent increases and just cause requirements, property owner is advised to seek legal counsel from a qualified California real estate attorney. So what they're basically saying is if you have any questions, don't even bother looking at the forms. Call your attorney, because that's where this is going in terms of, does this comply or not? And again, this form is, now is 3-4 months old, so it may or may not apply. And this one, for instance, is only applicable for non-rent residential obligations incurred between March 1 and August 31st. So you can kind of see a theme here. The next couple of forms are similar, right? We're looking at the same type of thing where we have time frames. Here's the one for September 1. We just had we had March 1 to August 31st. Well, here it is again from September 1 to January 31st. Here's that time frame for the notice to cure. And then here's another one. This is the notice to pay, right? Here's the notice to pay for a time frame from March 1 to August 31st. So again, there's a theme here. They keep going like this. Here's the similar form for the same time frame. So it's not as daunting as it really seems. I probably should throw that caveat. When you say there's 15 new forms, there really aren't. There's probably 6 new forms, but they have different iterations for different time frames. So just make sure before you use any of these, you're looking at the top and then going through what you need to do to evict. And so with that, I've been talking for about an hour and 45 minutes here. There may be some questions and so I'm going to stop on these forms for now and see what type of questions that we see. Let's see. So I see. Thank you for clearing this up. The forms RCJC dated on zip forms is not the same as you discussed. Neither are all the other ones. What am I missing? These are the forms. These are the forms that are coming out. So you may not have updated the software. Hopefully the software has been updated. These are the forms from CAR. If you go on the CAR website, you'll be able to see these forms that have been recently released. And it looks like, back to the question about buyer personal letters with RPA. As agents representing buyers, we usually type an email with information to our buyers. Similar, is this okay? So I think what you mean by that is you would type out you'd be typing out an email with your buyer's information, essentially writing their letter. That probably is even more risky. That's probably even more risky, because now you're inserting not only are you delivering it, but now you've kind of inserted yourself into the actual, you're actually authoring the letter, even if they, told you what to write. The guidance we're getting from CAR is not to do them at all. So, or make them extremely generic, so they're probably worthless. Is really what I'm hearing. Like I said before, and someone's saying here, it's this common practice to tell a listing agent about our buyers. I know it. I completely 100% agree. And like I said, I know agents personally who do this. My friends, and I told them about this when they were discussing this at CAR, and they're like, that's crazy, right? That's how I've sold 3 houses this year because of that. Or I've been able to buy. And so it's certainly, I know it's common practice. I know this is the way it works. What I'm telling you is what CAR is directing you, with the state of California, really. It's really not CAR. It's the state of California is telling you that they're going to be, they're going to be cracking down on this as discriminatory practice. Now, will they? I don't know. I haven't seen one yet. I haven't seen one yet come down on that yet, but we will see it. I'm sure, right? They wouldn't put that in there. They wouldn't discuss it at CAR if people weren't concerned about it. So, you know, do I tell you don't do it? You know, I'd say that that's the best practice, and you end up doing what you're going to be doing. Like I said, I got to put through my kids through college. So, you know, I'd love to see the claim so I could perhaps defend it. But remember, it's not just the intent, right? It isn't your, you know, because I don't know anyone who wants to discriminate, right? I don't think anyone's out there to say let's discriminate. Let's make sure that we steer this person, or it's not the intent, it's the effect, right? That's what I wanted to highlight in that statement there, that it's the fact that you're using a picture is, you know, has a discriminatory effect, right? So, you know, you put a picture of me on there, and, you know, you can tell what I look like, right? And so that could have a discriminatory effect if someone didn't want someone who didn't look like me. And so that's really the effect of it, even if there was no intent at all, because I don't know anyone who's purposely intending to discriminate. I mean, I'm sure there are people out there, and but that doesn't seem like a good business practice to me. I don't know about anything else, but that doesn't seem like a good business practice. So that's really the difference that I would see out there is CAR and state of California just saying don't do them. But like I said, I'll expand on this. I'm doing a presentation on the RPA coming up, and specifically on these letters as well. I'll try to show some examples of what, you know, of what type of what they're talking about during that presentation. And then to see that, please go on the NSDCAR website, go to their webinars. They have a whole slew of them coming up that you'll be able to you know, get more information. Let me share my contact information, because we're about here at the end of this presentation, and I want to make sure that you have. Oh, look at that! I'm right past it. So this is my contact information. Hopefully you guys can all see this. If you can't, maybe Shirley can tell me. Oh, uh-oh. I think I killed it. Let me see here. Screen share. Hopefully you're seeing that. That's my contact information. Here's my contact information. It's just FWP at White and Bright, and there's the phone number. And please give me a call and shoot me an email. I love helping out people. I represent a number of real estate brokerages throughout San Diego County, and love to help you out if I can be of service to you and to defend this industry. So that's my contact information. Please feel free to follow up with me. I'm trying to open the chat again. I don't know what happened to it here, to see if there's any additional questions. But like I said, you can always follow with me afterwards. Oh, great. Well, I don't see any additional questions here. So I thank everyone for attending today. I hope it was helpful. And like I said, please attend my other classes and follow up as you see necessary. And I look forward to doing the next one. And thank you to NSDCAR for putting this on. We're getting so much better attendance than we ever did in person, and it's wonderful that we're able to do this and really get it, get to people, so you guys are getting less and less claims. So thank you, everyone.
Thanks, Fred.